Welcome. Thank you for joining us. We're pleased that you joined us from New Jersey to Nevada, Georgia to Colorado, and stops in between. We have many friends and clients on the phone, manufacturers that are part of the supplier chain of auto assembly plants. We also have members of the machine tool, food, service, and hotel industries. I'm Alan Kaplan of the law firm of Masuda Funai, Eifert, and Mitchell. This is part of our continuing series of webinars. We have an annual free seminar, usually in September. We have a wonderful newsletter that you could find and access at our website, www.masudafunai.com, where you could also use our search engine to find an article about today's topic. Joining me today is...
Hi, I'm Edgardo Villanueva, president of EMSI Consulting, a Chicago-based management consulting firm that has helped and worked side by side with companies for the last 32 years, helping to deal with both employment and labor relations issues, which of course we'll be covering today. Thank you, Alan.
Yeah, it is important for lawyers and consultants to work together. That's what Ed and I do. There are jobs that Ed can do as a consultant that I should not do. And there are jobs that I do that Ed does not want to do and should not do. That's why companies should be really careful to choose lawyers and consultants that know those boundaries. Ed is the persuader when it comes to labor law and these issues. He's the person making presentations to the employees. He and his staff are the people on the floor talking one-on-one to the employees. Each of our presentations will be about 20 minutes, followed by your questions and answers. So you can start even now sending your questions to Carrie. She'll then be asking us the questions. CLE credit has been applied for the lawyers on the phone, and we understand that HR professionals can self-report. If you need copies of the slides or an outline of the presentation to self-report, please contact us. I'm pleased to be representing Masuda Funai. It is a business-oriented law firm, mergers and acquisitions, corporate reorganizations, and financings, commercial real estate from greenfield projects to leases, sales and distribution networks, sales representative agreements, commercial contracts, and B2B litigation. The Employment Labor Benefits Practice Group represents management. Our focus is on flexibility. We advise clients to ensure corporate compliance. We also counsel clients on issues from hiring to terminations. We draft and negotiate employment and union contracts. We advise settlement when necessary, but we're not afraid to litigate. Now, as a former hearing officer, investigator, and prosecuting attorney for the National Labor Relations Board, I know that the detailed and arcane rules can be frustrating, but they can help defend a company. We use them to gain advantages for the company. So let's talk about these new regulations. They issued on December 12th, and they become effective on April 14th. As you may have heard in the media, a number of corporate organizations have filed a lawsuit against the NLRB to overturn the regulations. They are hoping that the court delays the implementation of the regulations. These groups have been successful in the past when they contested other regulations issued by the Labor Board. However, the reasons this time that they are asserting are much different than those that they asserted in the past. In the past, the whole issue went to the Labor Board's actual right to issue the regulations. These arguments go to the actual regulations themselves. And when we look at the regulations themselves, lawyers and consultants are scaring everyone. It's called the ambush election. It's called the quickie election. Big government is now taking over the rights of companies. But is the sky falling? Well, Ed and I have looked at these regulations in detail. We've really come to the decision. The answer is no, not necessarily. Companies still have rights and should know those rights and use those rights. There is a lot to know and a lot to do. Companies should not be ambushed. They need to be aware of union organizing and to take steps to protect themselves. It's time for management, HR professionals to think strategically. The new regulations are in the context of unions becoming more active. Ed and I, working together for companies, have experienced the growing corporate campaign strategies of unions. They apply pressure wherever and however they can. Ed was telling me about the public demonstrations covered by the media at one of our clients and responses by the employees. There have been surprise OSHA inspections. Unfair labor practice charges have been challenging the company's policies and the random drug testing procedures. Another company got pressure from a politician to sign a neutrality agreement. That neutrality agreement would force the company to be hands-off during a union organizing campaign as a quid pro quo for getting government approvals. Taking the lead in all these actions is the National Labor Relations Board, an agency of the federal government I worked at before entering private practice. Obama now has all appointees confirmed by the Senate. There's a full slate of 5 appointees, 3 of them Democrats. Did you know that employees and unions can now use the company's email system to solicit for members? Did you know that employees can criticize management and social media without being disciplined or terminated, depending what they say? Unions can now petition to represent a micro unit. So think of your organization. Rather than asking to represent just all of the production and maintenance workers, a union could seek to represent just the second shift workers or just the painters on the assembly line. A company just needs 2 employees for the government to certify the union as the employee's exclusive collective bargaining representative. What does that mean, exclusive? That means that you are not able to give a favored or an excellent employee a raise or a bonus without first bargaining with the union or getting its consent. The number of union petitions has held steady at about 2,000 since 2006. Unions are winning over 60% of all elections. That's why companies need the EverReady anti-union campaign that we have created. It is a program and a process. It tests the company's union vulnerability. It helps you organize the workforce in light of possible union activity. It looks at policies. Are they lawful? Do they set the parameters of employees' activities? The program identifies those issues that will be litigated at the Labor Board. Most importantly, it creates an educational program so that employees understand that the vote for or against the union is one of the most important decisions they make as an employee. In addition, these policies help you avoid EEOC claims and other liabilities. Why are the new regulations particularly important? Because a company will now have less time to react and defeat a union campaign. For weeks or months, the union campaign will be like the iceberg that sunk the Titanic. The employees' activities are secret and hidden from management. For those companies without an EverReady campaign, the first time they hear about the union is when employees start wearing union buttons and announce union meetings. It's almost too late. Sometimes the first time a company finds out is when the Labor Board's investigator calls them and tells them a union has filed a petition asking for an election. I've been that investigator who's called the president of a company. Usually the reaction is stunned silence. Then they call their corporate lawyer who may not know what's going on. But action must be taken as soon as possible. All the union needs to file a petition is 30% of the employees in a unit, a group of employees that the union wants to represent. For a well-known grocery store restaurant in Chicago, there were just 8 operating engineers working on the HVAC system. The union needed only 3 signatures to get an election. However, usually unions will not file a petition for an election unless it has 70 to 80% support. Remember those figures, 70 to 80% of support when they file a petition. That's because studies have found that unions immediately start losing support once a company begins its campaign. The longer the period of time between the filing of the petition and the election, the easier it is for a company to win the hearts and minds of the workers. In over 90% of the cases, the unions and companies agree on the details of the election, the size of the voting group, and the eligibility of the employees. However, there are important issues that the company and union may not agree to. That's why the first step is preparing for the hearing or whether the company will sign the election agreement. What is the appropriate unit for the union to represent? Let's look at a small hotel near O'Hare Airport. Should the housekeeping employees be in the same unit as food and beverage workers? They have the same supervisor. What about the team leaders? Are they supervisors or employees? Under the Labor Act, supervisors are not permitted to be represented by a union and should not vote. Remember, Ed, how you collected information so we could determine the loyalty of those team leaders? The question management had was whether or not the hotel wanted them to be voters so that they would vote against the union. If the union won, however, the team leaders would be in the union. We then talked to the company. The company really wanted them to be supervisors so that they would not be protected by the union's grievance and arbitration procedure, and management could terminate them at will. The time to decide these issues is now before the petition is filed. If there are no issues, the company will sign an election agreement. It lists the employees included and excluded from the unit and sets the date, time, and location of the union. When the union and company disagree, the labor board holds a hearing. The regional director issues a decision in direction of election. The company must post a notice telling the employees about the election and who can vote and who cannot vote. In the meantime, the company may ask the labor board in Washington to review the regional director's decision. The labor board may delay the election and impound the ballots. The union wins when it gets 50% plus one of the votes of the employees who actually vote. Therefore, during the weekend before the vote, both the company and the union count votes. It is at that time that the union makes the decision whether to continue with the election or to withdraw the petition. Now remember, that's 70 to 80%. Although unions are winning over 60% of elections, unions are also withdrawing more than 30% of the petitions they file. That's because they've lost support. That's because the company has campaigned against the union. When a union withdraws a petition, it can refile it after 6 months. When the union loses the election, they have to wait a year. That's why Ed and I revisit companies where we have won to make sure that the company is making sure that the union will not have support. The election is by secret ballot and usually on a payday. Ed advises this, as do lawyers. We want as many union employees to vote as possible. In the first election Ed and I ran, out here in a suburb of Chicago, every voter voted. And the company won by one vote. It was Ed's consultant subcontractor who spoke to the Vietnamese employee that won the day. After the election, the loser can file objections to overturn the election, or employees may have been challenged when they voted. After the vote or after the hearing, the labor board certifies the union as the representative of the employees or certifies the results that the union lost. Of course, if a company is stuck with the union, the company can refuse to bargain and can appeal the certification all the way to the United States Supreme Court. So let's look at a very well-known example that made all the media this last year on how the current procedure works and how it may well help the company. The College Athletes Players Association filed a petition to represent the grant-and-aid football players at Northwestern University. CAPA filed its petition in Chicago, where pre-election hearings are usually held and scheduled within 13 to 15 days after a petition is filed. The hearing began on February 12th. It was 60 days before the regional director issued his decision. And as you know, he ruled that the players are employees. Northwestern had 7 days to give the union a list of the voters' names and home addresses so that they could campaign. That's called the Excelsior list after a case that created the rule. Northwestern filed a request for a review, and it was almost 90 days to the election. The football players voted and the ballots were impounded. The case is now pending 1 year later in Washington. But importantly, Northwestern had 90 days to campaign. That's a lot of time for Northwestern to tell its story to the players. And what's really interesting, they contacted the players' parents. By the time the board decides, a different group of student employees will be playing football at Northwestern. So let's say the union won. Just how strong will the union be to get the contract terms it wants? The Northwestern case was unusual, but the median time to an election is now 39 days, 6 weeks, to plan and present an educational program to the employees to convince them to change their minds. How do the regulations decrease the time between the filing of a petition and the election? Most pre-election issues will be decided after the election. Importantly, the new regulations eliminate the 25-day waiting period. The ballots will not be impounded. Washington will not accept every request for a review of a regional director's decision. And Regional directors have much greater control over the hearings. They don't have to listen to every single issue that comes up, and they can require lawyers to tell them what the issues are and then prevent them from bringing up issues that they have not raised. This means that unions can have an election as soon as it wants. If it has 70% support, the last thing the union wants is delay. So let's look at an example. Today, pretend that you got a call from the labor board that a petition has been filed by a union. Rather than 15 days, the hearing will take place and will take place in 8 days. It will not be extended except for an emergency. That means you have 8 days to examine that petition, to figure out what group of employees the union wants to represent, to find a labor lawyer to represent you at the labor board, to find a consultant who can be a persuader, to talk with the employees and find out what's going on. What are the issues? To determine those issues important to the company's future operations, as, for example, with supervisors and team leaders. If there is a hearing, the regional director could issue his decision within 4 days after that hearing. The company then has 7 days to give the union the list of employees' names and addresses. If the union does not want to use that list, it can have the election within as little as 20 days. With the list, if the union needs it with 70% support, the election can be within 30 days. That's still faster, 4 weeks faster than 6 weeks. The regulations also include a lot of other help for unions. Currently, a company posts a notice about the election after the election date is decided. Now the company must immediately post a special notice. This is a notice of the filing of a petition, telling the employees about the petition and obviously giving a lot of publicity to the union. The company also must give the union immediately a list of the names of the employees in the group, in that unit, petitioned for by the union. Therefore, even if the union has support from only 30% or 50% of the employees and was underground, the union gets a list of 100% of the employees' names, jobs, shifts, and work locations. In addition, hearings are limited in scope. Whether team leaders or supervisors may well not be litigated before the election. The issue may be litigated after the election takes place. Now, of course, companies can challenge the ballots of the team leaders, but if the team leaders' votes are not determinative of the results of the election, if there's a clear winner by one, then those team leader ballots will not be opened and the issue will not be litigated. There are also many other technical changes in the regulations that really interest lawyers. We get all excited about these changes. But for companies, the most controversial regulations are about the ballots not being impounded and about the 8-day hearing that requires companies to really move quickly. Also, the regulations require the companies to disclose the voters' home telephone numbers and home personal email addresses if you have them. But what's interesting, bending to the complaints of the business community, the Labor Board decided not to require the disclosure of voters' business telephone numbers and business email addresses. So we've talked about the regulations. But you know, there's an old expression, what's good for the goose is good for the gander. And all we've heard as companies and HR professionals is how terrible these regulations are for companies. So can this regulation help the process of getting rid of a union? And on the phone today, there's a number of companies, hotels, manufacturing facilities with unions in certain facilities. So can this regulation help decertify a union? The answer is yes. Of course, subject to NLRB interpretation. If your unionized employees are dissatisfied with their union, this kind of quickie election, I think it could help the company. You know, Ed and I represented several years ago a small manufacturing company where the employees told management that it no longer wanted to be represented by a union. We helped that company because we filed a petition for an election. It had to be done in a very special legal way according to NLRB guidelines. We wanted the employees to vote out the union. The company had to wait 6 weeks for that election, even though Ed had spoken with the employees and we had support to get rid of the union. During that 6 weeks, the union campaigned. Fortunately, again, because of Ed's persuader activities, the union lost the election. The company is now union-free. Ed just visited them last month. But what every company needs to do, obviously, is create an EverReady anti-union campaign. The campaign is a joint effort between management, human resources, and outside counsel consultants. Here to talk about the role of the persuader consultants is Ed.
Okay. Well, thank you very much, Alan. And again, I also want to welcome everyone. I know that there are several participating or companies that are tuning into this webinar that I've worked with in the past, and many others whom I've not yet had the opportunity to meet or the pleasure to meet or work with. Looking forward to that. But let's get on to this. The next part of our program. Alan and I have mentioned, or Alan mentioned over and over that he and I have worked in several cases, and that's the kind of partnership that leads to success and to helping the company establishing its goals. For my part, EMSI Consulting is of course a management consulting firm. We do have, as he also mentioned, multilingual, multicultural capabilities where the workforce requires that. We customize our services to make sure that they're tailored to your needs and build upon what you have already built to enhance positive work environment and hopefully to keep you from ever having to deal with unions altogether. All right. So let's talk about the experiences I've had as to what leads a workforce to even want to turn to a union. I kind of narrowed it down to some degree to 12 items. Most people think, the very first one that comes to mind is, why would anybody turn to a union? Because they want more money. And of course, that's true. Everyone, seeking advancement and better pay and so forth. But it's not just the amount of money people pay, companies pay, but we find an inconsistency in pay practice where that kind of unfairness in terms of compensation can lead people to a union. But there are many other reasons people turn to unions. For example, of course, if we look at benefits, have new benefits been introduced or increased expenses in benefits or some taken away, etc. Those are the kinds of things that a union organizer will certainly be talking to your people about. So when we get into the point about what action steps to take, certainly these are the kinds of things that could be trigger points, and you need to be looking at what corrections to be made. Unsafe work conditions, obviously, if people have told me on countless, production floors or walking the halls of a hotel or a hospital, listen, we've been asking for certain these change or these safety gear or something of that nature, and the company's not responding. Those are the kinds of things, again, that are ammunition for the union. What I would label job insecurity. If people feel like they could be subject to unfair firings or somebody got fired at another department that was popular, sort of a martyrdom was created. People feel as that their supervisor at any point can, fire them. That's going to lead to a union talking to them about the idea of a contract or protection, et cetera. Okay. We'll also be talking, by the way, about at-will statements in handbooks in a few minutes, because that sort of falls into this category. The lack of respect for seniority. Seniority is a word that most people, I've had many clients almost refuse to use the word, and that's okay, and service credit, call it what you will, but people feel that if they've given a sense of loyalty to a company over years, and there is lack of respect for that in terms of job assignments or promotion opportunities or even pay scales, then that certainly can lead to unions being appealing. Obviously, communications, and not just in terms of telling people what's going on, but also things like, for example, communicating the need for overtime or policy changes that have not been adequately explained or communicated. Those are the kinds of things that people, cause emotional reasons for turning to a union. be alert as to how your discipline procedure is. You know, there's inconsistency perceived or favoritism perceived. You know, I got written up for this, but somebody else did not for the same thing. Issues that involve people feeling like they're overworked. You know, they've been given increased duties. They're short on staff, and they don't perceive the company doing anything to help. You know, you're doing more work today, but not getting paid anymore. That will certainly be a cause for a person to say, well, maybe we need an outside representative to help us, you know, against these unfair positions. Favoritism is something that I hear all the time. Personal biases. If a family member is part of the management team or part of the workforce, are they getting, you know, favoritism or favored treatment, I should say? Okay. Obviously, people. And if there is no upward mobility, these are the kinds of things that, again, people will get frustrated about and turn to a union. And these are all issues, okay? And lastly, I've put in here, no attention to personal problems. People are people, and they, you know, things come up in everyone's life, and so they expect or hope to be able to get some, you know, flexibility, let's call it. And if you're a non-union company, you have that flexibility. Now you have to use it discreetly so that you don't have favoritism. But people, when they feel like their personal issues are not being attended to, that emotional scar can often lead them to have a sympathetic ear to an organizer. Okay, so now, what are some of the action steps then, given the reality of the unions are certainly still out there, and the new regulations? Okay. I've broken this down into 4 different segments. First, know your people. Then, know your leadership team. We're going to talk about this in more detail. Know your company, and know your rights. What are things that you should be doing assertively or, you know, up front now to get ahead of the curve on especially with the abbreviated time frame that the new regulations provide for in the event of you being a target of a union. Okay, let's start with knowing your people. It starts out on an individual level. You know, first of all, know who you hire. I can give you countless examples of situations where I've been interfacing with the workers, and then I go back to a management team and I say, do you know that so-and-so who works in such and such department used to be a shop steward at XYZ company before you hired them, and is very sympathetic to the union cause? And I've had a lot of blank stares. So we have to understand, and certainly doing the proper reference checking, and be careful of you know, either unlawful discrimination and so forth, but understand who you've hired and you know, be alert, especially during an orientation period. Okay, have accurate and up-to-date profile sheets on your people. If there are significant events in their life, you want to know what's going on with them, if they're upset about certain things, or if anything has changed, so that you can respond to it proactively rather than react to it after it's too late. Identify, you know, their strengths, their weaknesses, their character, who they are they on your team, are they not, and obviously look to enhance the positives, maximize their growth potential in the company, make sure that those that are showing leadership skills or capabilities are in fact being singled out or being given the opportunity to grow and to develop those leadership skills. Okay? In terms of an overall workforce level, identify the issues that exist out there, and the best way that we've found is to simply conduct an employee opinion survey. We've done many of these throughout the country with many different work settings, including, by the way, in unionized companies. Employee opinion surveys, as long as they don't violate any of the collective bargaining restrictions, are an important tool. I find, however, that sometimes companies are afraid to even open up that door for fear of what they might find. Don't be afraid. It's important to know up front what's going on out there. Know your leadership team. They're your first line of defense and your first you know, impression, if you will, for your employees, and your first wave of opportunity to create an environment where unions are not appealing. Okay, ask your supervisors and managers, how do they view and describe the workforce? you might be surprised. I found many situations where leaders or supervisors are openly disrespectful of the people that they, in fact, are supervising. You know that that's going to probably lead to problems and conflicts on the floor. What's been their past impact on the workforce? If you have a supervisor out there who you receive positive responses about, great. What about if you receive negative responses about a supervisor? What are you doing about that? And if it's neutral, you know that that's probably not accurate because something has to be happening out there. So understand or look at, you know, the leadership team that you have out there. Are they, in fact, working on your best interest? Okay. How do they describe their role in participating to achieve your company's goals? Are they active? Are they enthusiastic? Are they engaged? Or are they just simply neutral or potentially even negative towards the company's goals? If that's the case, obviously you have a problem that could leave you vulnerable to an outside organizer's appeal. An action step would be to provide them with ongoing, targeted leadership development education. We have a client right now that has committed to a long-term program with one of our key consultants, trainers, to provide their leadership teams with ongoing education, because it's not, you know, you don't get a high school or college diploma by attending one semester of school. Education is an ongoing process, or they certainly are not going to be great leaders overnight by sending them to a half-day seminar or a one-day seminar somewhere. So be sure that you are developing this team, because at the end of the day, that's where, you know, you're going to have the most the most important group in your organization to either incite or diffuse union organizing. Okay, know your company. Well, of course, in this case, you know, you have to look at how you how your policies are perceived, how they're written up. Are they fair in the eyes of your employees? You got to put yourself in their shoes. You know, I've had, again, many anecdotal stories about people who have stopped me and say, well, you know, this policy is just not fair. Many companies use various forms of attendance control, a point system as an example. And somebody who said, well, how come I get a point if, in fact, I can prove that I was sick or was injured or in the hospital? Okay. Now, again, each company has to develop their own policies, but if they're not perceived as being fair and consistent in the eyes of your employees, as the old expression goes, perception is reality. Okay? Ask yourself, how would a union organizer use them, in this case I'm referring to the policies, to his or her advantage and use it against you? Are your policies communicated properly? Sure, you can give a handbook to a new hire and say, sign in the back sheet acknowledging you received it, and make sure you read it at home. But are they in fact doing that? Are you actually taking a proactive steps to communicate your policies properly? And if you have multiple languages or a multicultural workforce, multiple languages are necessary. You hired them and you knew the restriction perhaps in the language situation. I've had managers say, well, they need to speak English. Well, you knew they didn't really when you did the interview. And so when you're going to communicate your policies, you want to make sure that these policies are understood. Okay? An action step, obviously, is to review your current policies and practices. We're going to talk a little bit more about that in the next slides. Know your rights. Very quickly, prepare and distribute a clearly written, up-to-date employee handbook that includes, and here are 4 key things. 1, a legal no solicitation clause, and that's where folks like Alan come in to play, to be sure, because the NLRB continues to change and move the goalpost on this in terms of what is considered legal and non-legal when it comes to no solicitation clauses. A legal social media clause is very necessary now, given, again, NLRB regulations recently. A credible internal problem resolution clause. You know, unions are famous for selling themselves to employees on the basis of, we're going to be there to fight for you. And of course, we're all familiar with with union contracts and their prolonged grievance procedure forms. If you can create an internal problem resolution force that people feel is fair and credible, you will eliminate that selling point from the organizer. Okay? A non-threatening employment at will clause, and I mentioned this earlier. Employment at will clauses are necessary. I'll definitely go on record of that. But I've seen handbooks that not only are written in such a way that, of course, people can be left with no other interpretation other than, gee, they're going to fire me tomorrow, or it's repetitive. They mention it at virtually at every point. So let's, insert the will clause, but be selective about the way, and certainly explain it to employees what that means. Okay, an action step: you need to consult with labor and employment lawyers such as Alan, or even bring in outside resources like ourselves. We work with many companies to communicate effectively. Okay. Now, given all of that, I still find, of course, that many companies find justifications for not being worried about this, not taking action, not looking at their internal situation. Okay? And here's a sample of some of the reasons people have given me over the years, or companies have, for not being concerned about it. My business is too small for a union. Well, Alan mentioned no business is too small. If you have 2 employees, you're big enough. And of course, with the advent of these micro units now, where unions can kind of, quote, cherry pick a small segment of your population, no group is too small. My employees are happy. They would never turn to a union. Really? They may seem happy, but internally, if they're still perceiving that there's not that there's unfairness, or a supervisor is mistreating them, or their benefits are not meeting their needs, the perception of happiness doesn't necessarily mean they wouldn't turn to a union. I pay them well. Well, I remember my 12 reasons for people turning to a union. Money's one thing, but that's not the only thing. So don't rely only on the fact that you're a well-paying employer in your industry. If a union ever came in here, I would close the business. Well, you better talk to Alan about that first, because that could be obviously unlawful under many circumstances. So that's really not an option for not worrying about it. Unions are in the past. They're out of the limelight. Again, remember that they're still around. They still represent millions of workers across the United States, and they're looking constantly for ways to revitalize themselves. I treat my employees well. They would never want a union. You may have all the best intentions in mind, but if your supervisors on the floor are mistreating people, or if people are feeling that policies are unfair, they've come up to me and said, it's nothing personal. I really like my boss, but I think we need a union, has been an expression that I've heard many places. I never ask my employees to do anything I wouldn't do. That's admirable for an executive or a manager to be involved, and that's certainly necessary. But once again, don't rely on that on the basis as a basis for people not considering outside representation. And there are many others that I've heard over the many years. Okay? So remember that the union's current win rate in NLRB elections, Alan mentioned it's over 60%. Yeah, well, one of the latest statistics I saw, it's 66%. So every time they file an election, they got a pretty good chance of winning, unless you are getting ahead of the curve. One last thing, some thoughts about decertification. Alan mentioned that, in fact, it's true. The quickie election, if we want to use that term, under the new rules, could be now beneficial for companies who would like to, or who feel, or have an opportunity, I should say, to become union-free. Now, some very quick thoughts about that. Okay, if you're a unionized company, and those unionized employees have voluntarily expressed their dissatisfaction with union representation, and believe me, I've heard multitudes of versions of that dissatisfaction expressed by employees. This union never does anything. They never show up. They're never around. I call them and they don't respond, or we're not getting anything, etc. If any of those kinds of statements are being said, listen for what I have to refer to as the magic words. If their dissatisfaction turns into an inquiry or a question, such as, how do we get rid of this union? Or what can we do about this union? Or do we have to stay with this union? Or any version of that, that opens up the opportunity for you to engage in dialogue. If people have, in fact, asked a question, they deserve an answer. There are two legal ways, and this is a very simplified explanation, to decertify a union. Right? One would be the filing of what is known as an RD petition with the NLRB for an election. This is where employees themselves take the initiative to ask the government, let's have an election because we want to see if the majority still want to have a union. It's an employee-driven effort. But there is another method that many companies are not aware of, and Alan and I have used this very successfully and legally. It's an RM petition, a management-driven petition, where the management asks the government to conduct an election in order to test to see whether, in fact, the union still has the majority of people on board. Alan and I did a webinar specifically on this subject, and if you'd like to contact us later, we certainly would be welcome to send you that information or simply speak with you. Okay. So, who should be on your EverReady team, as we've labeled this presentation today? Certainly you have to have the buy-in of upper management, top executive management, or someone represented executive top management. Now, in many companies, human resources departments are part of the upper management, but I put it separately because HR plays a particularly important role in creating alertness and being, and being aware of the signs of unions, et cetera, that and taking action steps. Okay, you should definitely have people from the production or the staff management, general manager of a hotel, or the production manager of a factory, or a director of nursing in a hospital, et cetera. Okay. You remember earlier we talked about looking at your people and knowing your supervisors and their strengths or weaknesses. If you have key people that are good leaders, that are respected out there, that's the kind of people you would need to have on your EverReady team. And of course, in addition, we always recommend that you have a good labor lawyer and a labor relations consultant. Okay. So, we're now going to have some opportunity to go into a Q&A format, but before we do, I just want to make mention that for many of you, anyone who attends this webinar is attending and would like to then follow up with what would obviously be a much more tailored and personalized discussion about your situation, Ellen and I are willing to speak with you. We could set up a Skype or go to meeting conference so we can look at each other and answer your specific questions as to how we can collaborate with you and your internal team to create the right work environment to keep you union-free in spite of the NLRB's new regulations. So I know that we have a few questions that were submitted. Is that correct?
Yeah.
So, Alan?
Yeah, thank you, Ed. When you and I were talking, Ed, we were about these new regulations. We were talking about there's really two funny, sad consequences. One is these new regulations have unintended consequences. Every regulation of a government has unintended consequences, and some of the questions we're getting goes to that. The other issue is that every act of a government is almost like a full employment act for lawyers, because all of this will lead to litigation and may well cause more problems than they've chewed on. And so, for example, we have two questions here about what I find to be a really troubling part of the regulations, and actually it's part of the lawsuit, and that has to do with the personal emails and the personal phone numbers that the company has to give to the union. So one question, for example, if employees have signed a card indicating they do not want their personal data given to anyone, is that justification for the company to withhold the information from the union? The second question that's related, if the union has the right to obtain employees' home phone numbers from the company, would it be better to stop storing the data in the HRIS system and instead have the supervisors maintain this information? Great question. I wish I had a specific answer. I think my answer is don't collect it at all. and because then you don't even have to give it out. To answer the first question first, if you have it, whether it's in the HRIS system or the supervisor, I could see the labor board saying you have to give it up. If you have access to it somehow, a supervisor is as much an agent as the president of the company, you have to give it up. How then are you going to collect it? All within 7 days and put it in a format and get it out? That's going to be difficult. And of course, as the question relates, if you have it with just the supervisors, perhaps there's a defense that you could have that it really would be burdensome to put together the information, and perhaps the labor board will rule, as they interpret these regulations going forward, that if it's an undue burden to put it together, you don't have to put it together. And that may well be a defense to giving out the information. Going back to the first question, what if employees have signed a card indicating they don't want the personal information to be given to anyone? That also is not covered by the regulations. It's something which I will search the comments. As you may well know, the regulations, after the regulations, there's about 600 pages of comments that the labor board wrote, really to protect themselves in the lawsuit. But I will search that to see if there's anything like that in the comments, and I could send an email to everyone who participated. I think, again, that's going to be litigated. The way this question will be litigated is if the union loses the election, they'll file an objection to the election, saying company has the data and did not give it to us. That caused an unfair election, and then it'll be litigated at a post-election hearing, which can then drag on for years and years the obligation of the company to recognize and bargain with the union. Because if there's no final decision, no final certification, the company doesn't have to recognize and bargain with the union during that period of time. Except with a caveat, there's some new case law which addresses that issue. We do have another question that came in here, this is for you, Ed. Which companies are the main targets for unions?
Well, across the United States, across the country, we are seeing that union activity is still fairly robust, and so they're going after any company that where there are opportunity for more dues-paying members. But specifically, we're certainly seeing a lot more activity that is geared towards minority workforces, Hispanics especially. We've probably all seen, the news coverage regarding the Fight for 15, which is a SEIU-sponsored organizing activity, even though they hide behind the fact that there are what they call community worker centers leading the protest. But that is targeted for fast food workers, and restaurant, hospitality, certainly hotels are a primary target at this point for union organizing attempts.
Yeah, I would say that an issue-free workplace is a union-free workplace. So what is a target? It's a company that has a lot of issues. Remember the slide that I put up about the Titanic and the underground activity? What the union is doing for months is trying to figure out what the issues are. And if this is a workforce that can be organized. And the very first thing I do and Ed does when we're called in by a company, we do the same research. What are the issues? What's going on? And so if you think you have issues, then you may well be a target. I remember a company in one of the southern states where the payroll clerk was a disaster. And the employees would line up outside the payroll clerk's office because there were always mistakes on the payroll. That's a target and became a target for the union. And speaking of that, Ed, there's another question here. Really, they're asking, what are the warning signs? What should companies be looking for?
Well, traditionally, we have always instructed companies to obviously be on the alert for employee complaints, people that are coming forward, talking to the, presenting their complaints or to the HR department and so forth. But in addition to that, I also point out to some other subtle things that we always find, and that is, again, knowing your people, knowing who they are, what their backgrounds are. If you have, and I saw this recently in a situation where if you have a relatively newly hired employee or recently hired employee, and that employee is taking it upon him or herself to probe and to be sort of the advocate for everyone, or to question everything you're doing. Why is this happening? Why is that happening? Or why are you doing this to so and so, or et cetera? New employees typically are happy to get a job, and therefore are not looking to create any kind of a negative impression. But somebody like that, frankly, could definitely be a plant by the union. We call it salting the workforce. But in addition to that, too, if you're seeing that normally there was a lot more open communication with a group of workers, and now they're sort of hiding away from you or shying from engaging in talk. There are also some of those signs that Alan pointed to in his iceberg example that companies often simply overlook. Oh, yes, we heard about the fact that there was a union talking to our people, but we didn't feel that there was anything going on. Well, a small spark can certainly lead to a larger fire. I even had one example in a San Francisco-based company where I'm talking to one of the floor supervisors. He said, well, yeah, every time the union organizer kind of hangs around on the dock here with the guys, I talk to him, but he doesn't really mean anything. I said, what do you mean the union organizer is hanging around? That supervisor did not see or perceive the reality of what the mission of that organizer was. And sure enough, it led to an election, by the way, which thankfully we won. But there are warning signs that are either obvious or subliminal.
Yeah, here's a good one for you, Ed. And this is really controversial. Consultants and lawyers disagree with this two-part question with the answer all the time. So here's the two-part question. Can we put a clause in the handbook saying that the company desires to remain union-free? And the second part of the question then, can we talk about that during the hiring interview? That's quite controversial. I'll give you my answer, then we'll see if Ed disagrees.
Go ahead, and I think we're going to probably agree.
Oh, I don't know. Yeah. I don't know. Well, yeah, I think there can be a clause in the handbook that implies that the company can be union-free, and there's a lot of different ways to say it. My concern, and remember, I was a prosecuting attorney at the Labor Board. I used handbooks. I put up the HR person, the president, on the stand under cross-examination, and I pointed to the anti-union clause in the handbook, and I was then able to establish anti-union animus. So there's a way to do it. Should it be discussed at a hiring interview? My personal opinion is no. Again, it can be used against you. However, as many of you, because I know there's a lot of my clients out there, we talk a lot about behavioral questions. And a great question to ask during an interview: if there's a problem with your paycheck, what do you do? If the answer is, I go immediately to HR, that's a good employee to hire. If the answer is, oh, I'll contact my union steward, that's not a good answer. All right, so Ed, what do you think? Should there be a clause in the handbook that we want to be union-free?
Well, I'll leave that to your answer, because that's a legality. I certainly, as a non-lawyer, I would say, of course, there should be, a statement saying we're a good company. We'd like to remain union-free, and I know that that's changed. But the second part of the answer, the communication part, and I'll go beyond just the interview process. I think that communication to the workers about relevant issues, including the fact that we strive hard to create an environment where people feel that they could have a fair hearing internally, or that we provide good benefits and competitive wages and so on. By reminding them that the company's practice, ongoing daily practice, engages employees and provides for opportunities to air out and resolve issues, I think that certainly has to be communicated consistently. be aware of the fact that when a person comes in for an interview, they're definitely going to be putting on their best, their best face. Secondly, of course, they're going to, hear your questions or your statements, but all they're interested in is getting the job. And the same thing for the person who comes in that first day of the job and goes through an orientation process. They just want to get on the floor and look forward to collecting their first paycheck. So a lot of things that you may say up front to people during that time frame may not sink in. So that's why I continue to repeat, communication has to be an ongoing process. And yes, I think it's fair to remind people that the company's stated goal is to work together, to work through issues, to resolve problems, and that there is an internal process for the airing out of those things.
Yeah, I was very impressed by a major Japanese auto manufacturer, who shall go unnamed. But when we took a tour of that facility, we were introduced to the Employee Relations Department, which was a different department than the Human Resource Department. The Employee Relations people were on the floor all the time trying to find the issues and doing that communication. Here's another question. And I'll start the answer, then go to you, Ed. Who should we contact to find out more about a management-driven petition to decertify a union? Of course, that's the RM petition that Ed mentioned. I would start, believe it or not, with our website, masudafunai.com. Go to our resources and the Employment Practice Group page. Type in RM petition, and you'll see the article that I wrote on the election that Ed and I handled. You could also go to the NLRB website, and they have a search engine. It's a little difficult to get around, but if you wanted to do some research, you could certainly do that. Who should they contact about this, Ed?
Well, I'll just give you, again, practical response based on the actual situations that we face. Obviously, before you make any moves in terms of contacting the employees, be sure you're on the right legal setting, because you don't want to upset or derail the process from the very outset. So contact Alan Kaplan or contact the competent labor lawyer. But what I do when we get on the floor or on site with this is immediately, get as much information as possible about what the employees have been saying. And as long as we can provide employees with lawful answers and information, and now I'm talking about the actual workers who have expressed the dissatisfaction, as long as we have never been challenged legally nor found guilty of any unfair labor practice charges, and those efforts have in fact led to elections, or in one case, not too long ago, we had a situation where the union had been around for 20-something years at a large baking company, and they saw the writing on the wall, and basically they just withdrew. We also had that at another manufacturing company, Chicago area. The union just simply withdrew before going to an election. So RMs are doable. They're tricky a little bit, but certainly, they are definitely a legal path towards a union-free workplace. I think we're running out of time, and so I guess again, I want to thank everyone for participating on my end, and Alan's also, reminding you that you're entitled to a follow-up, personalized video conference. We can set it up with you to answer specific questions regarding your company, and that's no charge, obviously. And we look forward to staying in touch and at some point being of service. Thank you again on my end.
And thank you very much.